Well, welcome officially, everyone. I'm Randy May, president of the Free State Foundation. And today's event, as you know, is a conversation, a fireside chat, really, with two FTC commissioners, Noah Phillips and Christine Wilson. And joining me in the conversation today with them will be Ted Bolema. I'm going to introduce all of them in just a moment more formally, but I do want to thank you again for joining us. This event today, this fireside chat, is actually the kickoff event for the Free State Foundation's 13th annual Telecom Policy Conference. I think really the last couple of years we've just called it the Policy Conference as we've broadened out. Sometimes I slip up and add Telecom. Next Tuesday at 11 o'clock, we'll be having another fireside chat with FCC Commissioner Brendan Carr. Not to worry, I put aside some firewood, so I would still have some for next Tuesday for that fireside chat. So all of the previous conferences, except one, were held at the National Press Club, not in the Zoom room. Indeed, last year's annual conference, held on March 10th, I believe was probably the last major conference held in DC after the beginning of the pandemic. I know the Press Club has not had any other conference that would come close to matching the number of people we had at our annual conference last year since then. So when I left that conference last year on March 10th, there was a very big sigh of relief that we were able to get that in. As many of you know, joining us today who have attended the previous annual conferences, one of the hallmarks of the event, aside from the great programming, of course, have been those sumptuous buffets that we always have at each conference. And hopefully we're going to be back in the Press Club next year. I'm confident we will be. And I owe everyone another great buffet next year. So you can count on that. And we'll be able to give each other, if not hugs, at least good elbow bumps. But until then, we're all together this year, at least virtually. So while I'm thinking of years past, I do want to mention that this is the Free State Foundation's 15th anniversary year. In June, we will mark our 15th anniversary. Every time I say that, I have to say, wow. I remember saying wow back on the 5th and the 10th. But it does call to mind for me a lot of very pleasant, happy thoughts about what we've accomplished. I'm determined that before the year is out, short of going to jail for doing it, that we'll be able to do a live in-person celebration of some sort or another, and maybe tip some champagne. So look forward to that. So now I'm going to introduce the speakers for today's event. Before doing that, I just want to remind you that throughout the event, please feel free, of course, to tweet. The hashtag is FSF Conf 13. That's FSF CONF 13. So please do tweet during the conference if you're a tweeter. Okay, it's my pleasure now to introduce our speakers, and we're delighted and honored to have with us the two FTC commissioners. First, Noah Phillips was nominated by President Trump to be a commissioner at the Federal Trade Commission and confirmed by the Senate unanimously on April 26, 2018. You don't get to use that word unanimously too much these days with anything in the same sentence as the Senate, but Noah Phillips was confirmed unanimously. And before coming to the FTC, Commissioner Phillips served as chief counsel to Senator John Cornyn on the Senate Judiciary Committee. From 2011 to 2018, he advised Senator Cornyn on legal and policy matters, including antitrust, constitutional law, consumer privacy, fraud, and intellectual property. Of course, you'll recognize that those areas, most of them are at the heart of what the FTC does. Prior to Senate service, Commissioner Phillips practiced law at Cravath, Swaine and Moore in New York and Steptoe and Johnson in Washington, D.C. He began his career at Wasserstein, Perella and Company, an investment bank in New York. Normally, I don't actually go into all the college and advanced degrees, but since it's March Madness time, I'm going to do that today. Maybe some of these schools might be in the big dance this year, and I confess I haven't kept up as much as I usually do. But Commissioner Phillips received his bachelor's degree from Dartmouth and his JD from Stanford Law School. So welcome and thanks for being here, Commissioner Phillips.
Thank you, Randy.
Next, Commissioner Christine Wilson was sworn in September 2018 as a commissioner to a term that expires in September 2025. She previously served at the commission as Chairman Tim Murris's chief of staff during the George W. Bush administration. In between her periods of service at the FTC, Commissioner Wilson has practiced competition and consumer protection law, both at law firms and as an in-house counsel. When nominated, she was serving as Senior Vice President, Legal, Regulatory, and International for Delta Airlines. Prior to joining Delta, Mr. Wilson was a member of the antitrust practice groups at Kirkland and Ellis and O'Melveny and Myers. Commissioner Wilson graduated from Georgetown University Law Center, and she graduated Phi Beta Kappa from the University of Florida. I think the University of Florida is one of those teams in the big dance, I believe.
Yeah, we could have a friendly wager, Noah, that my schools are going to do better than your schools in March Madness.
I would wager that they would.
I
would wager that they would.
We have no deal then.
I think he has you there. Okay. Well, Ted Bolema is Executive Director of the Institute for the Study of Economic Growth in the Department of Economics at Wichita State University. Ted most recently was a senior fellow here at the Free State Foundation and currently serves on the Board of Academic Advisors of the Free State Foundation. Ted previously was at the Mercatus Center at George Mason University. Particularly relevant to today's discussion, Ted has been a trial attorney in the Antitrust Division at the Department of Justice. Ted has a PhD in economics from Michigan State University, and his JD is from the University of Michigan Law School. Ted, I think usually one or both of those two schools are in the big dance, I think.
Yes, yeah, well, Michigan's the only one left. Wichita State and Michigan State did not do well yesterday.
Okay, well, better luck as you go forward.
Yeah, still one to root for.
Go blue. Go blue.
Yes, yes.
Which team is blue? Michigan?
Yes.
Michigan.
Michigan, yes.
I'm going to not display any more of my ignorance of these teams as we go forward. But by the way, if I think I mentioned, but if I didn't, Ted is going to be joining me in the questioning today of Commissioners Phillips and Wilson. Okay, now just one more reminder of the hashtag is hashtag FSF 13. So we're going to get started, and before getting down to the really nitty gritty today, I want to start with this question. Both of you have been operating now for 2 months with the commission split 2-2 with a Democratic and Republican split, with Commissioner Slaughter acting as, or serving as acting chair. If you're like the rest of us, I suppose it's more enjoyable to be in the majority than it is not to be. But just tell us from your own perspective how you believe the FTC is functioning now with this new regime and the split that you have there. Commissioner Phillips, do you want to lead off?
Sure. And let me start by saying thank you, Randy. Thank you, Ted, and all the folks at Free State Foundation. First, for the work you do, and second, for having us. This is always a great event. You always gather such a great group of people. And I'm sure I speak for Commissioner Wilson when I say we're really honored to be a part of it.
Commissioner Phillips, 1 second, I won't interrupt you. I should have said, because I was prompted, and I want to say it to be really clear, make it clear that the commissioners today, as they always do at these events, that they're speaking on behalf of themselves and not for any others. And I apologize for not saying that right off the bat, but now it's on the record. Commissioner Phillips, go ahead.
Thank you for that caveat. Look, I think what I would say, I think I'd say a few things. The first thing that I would say is having what some people call deadlocked, meaning an equal number of Republican and Democratic commissioners, is not novel. It happened not so long ago with Commissioners Olhausen and McSweeney. But deadlock is the wrong word, because in fact, there is quite a bit of collegiality. There are a lot of issues on which folks agree. And that's actually probably, if you were just to count matters, not necessarily in terms of their scope or importance, I think you would find that the overwhelming majority have at least bipartisan support, if not unanimous support. You know, there are issues, I think, where we have seen over the last few years, some divides that do fall along partisan lines, certain antitrust matters in particular. And what you do when you've got a commission of 2 and 2 is that you try to figure out where you can get to 3 or 4. Look, I think it's not always the easiest, but it's something we do all the time. And it's a fun process. I won't say whether it's, in part because I don't know whether it's more fun to be, in the majority or the minority. Right now, we're just the commission. To be honest, I think the bigger impediment to work, if that's even an impediment, is still this COVID thing with which we're all dealing. It's much harder not to be together, not to be able to meet in person. That to me looms much larger than the particular array.
Or Wilson, do you want to add anything to that?
So I would echo what Noah said, and I would emphasize and underscore, absolutely, we have very collegial relationships. I talk with each of my fellow commissioners at least once a week. When we disagree, we try to do it in an agreeable way and to keep the lines of communication open. And I would like to commend staff who are working incredibly diligently and conscientiously to identify areas of consensus and to essentially thread needles where they can to get to the 3 or 4 votes. We have 4 commissioners with diverse and strongly held views, and staff has been incredibly patient in listening to those views and helping us identify areas of common ground and consensus so that we can continue to move forward on behalf of American consumers.
Great. Okay, we're gonna dig in, I think, with this first question, or really topic. I have on my cheat sheet here, considering competition policy, especially with regard to big tech. Well, that's a big topic, and we can break it down, and maybe we will as we go along into a whole bunch of discrete elements. But I want to start, I think, just this way, that obviously in the last couple of years, there has been increasing calls to, and especially with regard to the claimed market power of big tech. And when I say big tech, I'm just shorthanding it here now for Google, Amazon, Facebook, Twitter, the platforms, and there are others that could be included, but there are claims that they have market dominance that differs from firms in the past that call for new ways of thinking about antitrust law. And even aside from big tech, there are claims in any event that antitrust law needs rethinking, and that markets, we need to approach it in a different way in order to protect consumers, or some may claim to protect competition or to protect competitors, depending on the way they're thinking about it. And these claims, and we have the House report from the Democratic majority from last fall, would be one example, probably a prominent example. It was certainly a lengthy report, but there's discussion about revising the consumer welfare standard, the essential facilities doctrine, some ways of thinking about market power by creating presumptions in terms of market share and those types of things. So to begin, I just want to ask you how you now think about or respond to those claims in terms of your own thinking, and then we can drill down further as warranted. But maybe I'll turn first to Commissioner Wilson to respond, and then we'll ask Commissioner Phillips to add or subtract from that.
Thank you. Let me add my thanks to Commissioner Phillips' thanks, both to Randy and to Ted, and also to the Free State Foundation. It's a pleasure to be here with you today, and I look forward to returning in person to events with you at the National Press Club. So in terms of this this current wave of angst about big tech, there are so many different angles that we can discuss and drill down on. But as a gating factor, I'd like to emphasize that people so frequently paint with a broad brush when they talk about big tech or platforms. And I think it's important as antitrust enforcers to step back and remember that each of these companies operates in its own market or markets. It provides its own types of goods and services. And when we're looking at and doing antitrust analysis, we have to remember that antitrust analysis is fact specific, and it's particular to the questions that we're asking. And so market power is a fact specific inquiry. And what we mean by a platform is very fact specific. And so I think it's very important that we not paint with a broad brush, but remember that antitrust at bottom is a fact specific inquiry. Second, I always encourage people when thinking about, quote, big tech issues to remember there's a lot of angst on a lot of different levels. People are concerned about Section 230, people are concerned about censorship, people are concerned about this massive hoovering up of our data, people are concerned about market power. And in some instances, all of that unhappiness with the tech companies gets conflated and aggregated. And the result is to say, we just need to break them up. And what I try to encourage people to do is remember that each of the issues that I just mentioned, the privacy issues, the immunity issues, the antitrust issues, are unique issues that have their own well-developed tools to address them. And so instead of reacting in what I would view sometimes as a knee-jerk way and saying, let's break up big tech, I think we need to think seriously and carefully about each individual concern that's out there, and then how we can address those concerns using the tools that are best tailored to those concerns. And then finally, I would say, in terms of antitrust issues, we need to think very carefully about how to address the issues, not just in a fact-specific way, but beginning with the end in mind. It is a theme in the economic literature that both behavioral remedies and structural remedies that the government has sought under Section 2 of the Sherman Act rarely work out the way the government has intended them to work out. And when you look at the literature, you show that government intervention frequently and unfortunately results in higher prices and less output and less innovation instead of the converse. And so I think we need to begin with the end in mind. We need to begin in a very sober way, understanding that we do not have perfect information and that our intervention in the end may cause more harm than good.
Thank you. Commissioner Phillips, I'm going to turn to you, but maybe it's in adding to that, or maybe you could also address this. The antitrust jurisprudence for the last several decades has hinged largely on application of what we call a consumer welfare standard, which was not always the case before that. And as part of these claims and contentions that antitrust law should be reoriented. As I understand it, there are calls to revise that standard, get rid of it, jettison or whatever. For the benefit of our audience, if you could, maybe you could just articulate your understanding of what the consumer welfare standard means and whether you think that needs to be changed and in the context of adding whatever else you would like to add.
Sure. What I think the consumer welfare standard reflects as much as anything is the notion that the point of competition is not the protection of particular industries against competitive threats. It's not keeping things as they are. It recognizes a level of dynamism by focusing on what is good for consumers. That means low prices, it means high output, it means innovation, it means quality, it means a lot of different things, but the focal point is the results of the competitive process, not just say the structure of the market, not looking at goals outside of competition. Christine talked about some of this. A lot of the rhetoric you hear today, and I think a lot of the drive for reform, uses the language of monopoly, the language of breakups, to talk about a whole host of gripes, some very legitimate, with the power of large companies, including in particular, big tech companies. Antitrust law focuses on competition and the good fruits of competition. So that's what consumer welfare is about. There are two real benefits that it offers. First are coherence and administrability, right? Potter Stewart famously quipped before consumer welfare had been adopted that the only rule in antitrust, I'm going to paraphrase a little, was that the government always won. And so if you were charging too much, you were a monopolist. And if you were charging too little, it was predatory pricing. A merger producing absolutely no negative competitive impact was a problem because it was just growth. And that the only rule was that the government won. And that's not a rule of law. So the first thing is administrability. But the second thing, and I think this gets too lost in the conversation, is that things like high quality and low prices and innovation are good for consumers. They're good for Americans. And I said this yesterday at the House Judiciary Committee, I think we are going in the wrong direction if what we want to do is raise prices for consumers. And some of these ideas about allowing, small cartels to kind of make more equivalent power imbalances in the market will have that result. I do want to also pick up on Christine's point about remedies, and it's particularly, I think, apropos in the context of the Free State Foundation and a lot of the telecom issues that you discuss. So one of my favorite instances of this is, and it does read on the House report. In 1956, the United States government, concerned about the power of the biggest tech company in America, AT&T, among other things, barred AT&T from getting into the computing market because it was concerned that AT&T would use its power and cancel out competition in this new market. It was, 13 years later, not long, before the United States government went to court accusing IBM of having a monopoly in mainframe computing. Well, one of the reasons for that might have been the fact that they took the most likely competitor and barred them legally from intervening in the market. This idea, line of business restrictions, undoing the law on monopoly leveraging, is precisely the same idea. It is directed at limiting competition. And I think we just need to be pretty careful and speak very frankly about what some of these proposals mean.
Commissioner Phillips, just to pick up a bit on your reference to telecom law and the telecom world, and it is true that I've spent most of my career largely in that world, and so one of the suggestions has been, I think, picking up on the telecom experience, is that the big tech platforms, Google, Facebook, Twitter, whatever, that they should be subject to some form of, I think it's usually termed an interoperability requirement, which I believe implies that a consumer user should be able to take all of his information that Twitter has, for example, and take that information with them to Parler, if Parler still exists or whatever. And that of course is analogous to the portability regime that was established in telecom, and I think by most accounts an important element of getting to a more competitive environment. What do either one of you think about the imposition of an interoperability requirement as a government mandate?
So you mentioned, Randy, the attempts to rejuvenate the essential facilities doctrine, and frequently when people talk about injecting more competition into the tech space, they say we can either require certain platforms to be characterized as essential facilities and impose obligations on them to cooperate with competitors, or we can use interoperability obligations. And I would rather see interoperability instead of essential facilities. I think the essential facilities doctrine takes a very static view. It sees that an asset exists and it thinks that more competition would be available if that asset were required to be shared, but it doesn't take the dynamic view and think about the incentives of requiring sharing. I think it will lead to less investment and less innovation in the medium to long run. And so I am very concerned about breathing new life into to the Essential Facilities Doctrine. I think the interoperability concept is a very interesting and intriguing one. I think that there are some ramifications and consequences that we need to think about. So for example, the FCC actually obligated AOL to engage in interoperability as a condition for the AOL Time Warner deal, and AOL eventually said it was unable to meet the instant messaging interoperability obligations that the FCC had imposed. And so I think we need to think very carefully about whether interoperability is actually feasible, because if we impose it by fiat and then nothing happens, there will be significant disappointment. I also want to underscore the privacy implications of interoperability. So if Noah and I are friends, to use an example, if we're friends on Facebook, and he has posted a lot of comments on my timeline, or he has posted pictures on my timeline, then when I begin to download all of that information and take it to a different platform, I'm doing that without necessarily having Noah's consent. And so I think there are considerations with respect to privacy and other consequences that we need to consider as well. But at bottom, I would rather see interoperability preferably driven by industry than an essential facilities obligation imposed by the government.
One of our attendees did put in the chat line a note that a couple of the platforms, Twitter and Facebook, allow export of your information, and I guess then another platform would presumably allow import of that information. And that reminds me that I want to say later in the program, we are going to open up the chat line so you can put questions in the chat line for the commissioners. Okay, I want to turn to Ted now to ask the next few questions. So Ted, why don't you take it?
Sure, yeah, I'd like to follow up on the consumer welfare standard, and Professor Tim Wu of Columbia University has proposed an alternative test that I think is aimed a little more at looking at the motives for conduct. That he says that, or he proposes that the antitrust authorities ask whether the conduct is competition on the merits, which would be good, as opposed to an effort to disable or subvert the competitive process. Is that a useful way of looking at competition problems, particularly in the high-tech area?
I'm happy to start here. Look, I think that when you're building an antitrust case and when you're evaluating a factual scenario, one of the things that you look at is documents, right? What are people saying at the time? One of the things you do is take testimony and you hear their view. And people's intent can help elucidate a factual scenario. But intent is not the only question that antitrust asks, and it's not the most important one. Effects really are our focus. We want to know what effect is conduct having? What effect may that merger have? Again, I think intent can elucidate. But let me give an example. A lot of what we think about are economic incentives. So when we evaluate a merger, you may be dealing with companies that are very well lawyered, and they've done all the work, and there is no intent to be found. But the economic incentives, right, and what the data show in terms of how market actors behave, in terms of where consumers go, may tell a different story. And one of the things I find interesting about the particular focus on intent, I can't imagine Mr. Wu would want to take those kinds of considerations off the table. So is it part of what we think about? For sure. Is it the whole of it? Absolutely not.
Well, I guess we probably should note that Mr. Wu is over in the White House now, or in the administration. So we have to try and figure out what he has in mind, possibly. Ted, I know you had a question, I think, about the Qualcomm case and so forth. You want to go ahead and ask him the question?
Yeah, I'll combine that in with Senator Lee has proposed a one agency act to bring all federal antitrust enforcement under one roof at the Department of Justice. I was at the Antitrust Division back in the 1990s when the agencies weren't doing as good a job as you are today at allocating cases. So I might have been a little more sympathetic to it at that time. But one of the factors he mentioned in introducing his bill is the Qualcomm case, where the FTC won at trial, claiming that Qualcomm's licensing of its patents violated the antitrust laws. But then on appeal, the Department of Justice actually sided with Qualcomm and that one. So is that a good argument for maybe bringing up or having antitrust under one roof, or does that raise any concerns when the two major agencies can be on opposite sides of a case?
So first of all, let me say that I have tremendous respect for Senator Lee. And second, as a general rule, I do not opine on specific pieces of legislation. Look, if we were starting from scratch, would we have designed a system where we have two antitrust agencies? No, but this is the system that we have. And in fact, the FTC fulfills a unique purpose, I would submit. One of the things that I have always loved about the Federal Trade Commission is its innate desire to obtain information from all stakeholders. It conducts workshops and roundtables and hearings to obtain information to inform policy decisions and enforcement decisions. And so I think that is it's a unique aspect of the Federal Trade Commission that is built into the FTC's DNA. And we've had many successes on the policy front and on the enforcement front because of that energy that we put into assessing issues and thinking hard about policy evolution. With respect to Qualcomm specifically, I would say the Qualcomm case was an incredibly unique circumstance, and I think it should be viewed as an outlier. So the case was voted out, as you know, just 4 days before a change in administration. It was voted on a 2-to-1 basis, and the dissenting commissioner, later acting chairman Maureen Olhausen, wrote a dissent, which is highly unusual for sitting commissioners to do. Almost always we say that we will not provide a roadmap to defendants in cases that the FTC is litigating out of respect for the agency and for its staff. But she was concerned enough about the implications of this case to write a dissent. And when the case went to trial, there was no sitting commissioner that had voted on the case. And in fact, because the chairman was recused, we were in a 2-2 deadlock. The Republicans were not really happy about the case. The Democrats thought it was a good thing. And so essentially staff was operating on autopilot, carrying out the will of the previous commission on which no sitting commissioner had opined. And so I think this situation is so unusual that it is unlikely to reoccur and should not form the basis for modifying the structure of federal antitrust enforcement. But putting the Qualcomm issue aside, I do think it's important for the federal agencies to speak with one voice. I have long been a proponent of close cooperation between DOJ and the Federal Trade Commission. It's important domestically, but I think it's even more important internationally. We have made such significant strides over the last 20 years through the International Competition Network, the OECD, and other multilateral and bilateral fora, driving consensus on harmonization and convergence of best practices in antitrust enforcement that are founded on sound economic principles. And when the US DOJ and the Federal Trade Commission do speak with one voice in the international arena, they are a strong force to be reckoned with. When they are in disagreement, it is unfortunate and it can lead to erosion of sound enforcement globally, which ultimately affects US companies and US consumers.
Noah, did you want to add anything to what Commissioner Wilson said? Oh.
The only thing I would add, Senator Lee, for whom I also have a great deal of respect and affection, held a hearing in the last Congress on, among other things, the clearance process. And he had the chairman of the FTC, Chairman Simons, and the Assistant Attorney General, Makindel Rahim. I do, and to some extent, the One Agency Act tries to be a solution to what he viewed as a problem. I do think the agencies organizing what they do, companies not having to wait to, figure out who gets jurisdiction. I think smoothing that process, making the merger process more rational is a good thing for everyone. I think it's good for government. I think it's good for business. And most of all, I think it's good for consumers. So I do think whatever the solution, I think this, the problem at which he was looking is an important one, and we all need to work at that.
Let me ask you about a variation of what we've been talking about. It's actually part of Senator Lee's bill that doesn't receive much attention, but there's a provision in there that would take away from the FCC. Earlier we were talking about analogies between telecom law and competition law. Take away the FCC's merger review authority for competition analysis, assessment of competition. Frankly, for about 2 decades, I've argued that the FCC that it largely duplicates what the antitrust authorities do, and so for this purpose, just put aside whether it's DOJ, FTC, which one. It's just the duplication of competition expertise that resides with the antitrust authorities, and I've thought that this what he proposed or some form of it would be a reform that might be useful in speeding up reviews. I know you're not at the FCC, but and I think there may be other agencies where you have some of this type of duplication. I know perhaps in the old days with airlines, Christine, you would have had that duplication with transportation with the ICC. Do you have an opinion on that subject with regard to these specialized agencies and whether their independent review is necessary or useful? Either one of you have an opinion on that?
No, you want to take this one?
I haven't spent as much time studying the sort of FCC, DOJ interplay. My general view, consistent with yours, Randy, is duplication is not good. When you're talking about the context of a heavily regulated industry, I do think that input is important in evaluating the competitive process, because as we all know, right, the regulatory environment can have a tremendous effect on competition.
Right. Okay. I just wanted to get in a plug for something I've been, arguing in favor of for a long time in general. So Ted, before we leave this subject and move on to the next one, do you have a question you wanted to ask?
Yeah, I'd like to ask about the other major government player in the antitrust field, which is the state attorney generals. And there's several overlapping cases going on right now involving different combinations of the Justice Department, the FTC, and state attorney generals against Google and Facebook. And I'm wondering if that raises any concerns with you that with states getting involved in antitrust cases with potentially national implications. I mean, should the Attorney General of Texas be able to bring a case that affects how Google runs its business in Illinois? So if we could follow up on that and what you see as a proper role for state attorney generals in antitrust law.
So I think the state attorneys general can be an important force multiplier. I think they have a comparative advantage in dealing with cases that implicate local competitive dynamics and the interests of local consumers. They're closer to the ground with respect to both the facts and the way in which competitive dynamics play out in a local region. That said, I believe in federalism, and I believe that the right of the states to bring an antitrust suit, whether it's before or after the federal agencies have spoken to an issue, is not a right that I believe should be taken from the state government.
Commissioner Phillips, did you want to add anything on the state role here?
Yeah, just two brief things, mostly in agreement with Christine. I think the first is it's important to remember that the states were in the antitrust business before the federal government, right? The Sherman Act follows similar state efforts. And in fact, like the most famous breakup case of all, the 1911 breakup by the feds of Standard Oil, followed the dissolution of the Ohio Standard Oil Trust. The second point I'd make is what I think will be useful to consumers moving forward is to have a complementary role played by the states and the feds. Yes, there are absolutely some high-profile times where we're going to work together. But in particular, let's say in local hospital merger cases, the feds may not have all the resources to do all the work. And I think we live in a better world when instead of all doing the same things, and certainly rather than doing opposing things, which you've seen at least once, where we can kind of cover the field. And I can work on this one and you can work on that one. I think in the main, that's a better place for everybody.
Okay, I think what we'll do is move on to the next topic. Just for our audience and to reconfirm with our two commissioners, this is so much fun and so informative and so educational that I think it's 11:48, but I think you've agreed to stay on for 5 or 10 minutes afterwards so we can get in some questions, and that'll help me know where we're going. So I'm not even going to give you a chance to deny that. The next topic that I have, again, when I just write them out in big terms, was the problems with social media. Is there anything wrong the FTC could or should fix? And, we're all familiar with the discussions that we're having regarding social media and whether the force for good or ill in different respects, and whether they're harmful and non-harmful and so forth. And I think Commissioner Wilson, you allude when we were talking about this initial discussion regarding big tech, you alluded to social media as one of those things. But so my question is, and some of this has to do with political bias, some of it with our claims of political bias, and others, other types of harm. Is there anything role that the FTC can play or should play with regard to addressing these claimed harms that we discuss with social media, and especially within that, is there anything in terms of enforcing their terms of service or requiring that their terms of service be different in some way? Is there a role for the FTC? What are your views on that? I'd like to hear from both of you, but why don't you begin, Commissioner Wilson?
Sure, absolutely. So as you noted, there are a variety of different sources of concern about social media companies, big tech companies, and I do think it's important for us to disaggregate those sources of concern. With respect to privacy, I think privacy is a significant issue. The Federal Trade Commission has been asking Congress on a bipartisan basis for many years to pass federal privacy legislation that would address, I think, one of the most significant concerns about social media, the way in which our data is collected, used, shared, monetized, sold, and frequently in ways that are not at all transparent to consumers. And when I spoke last at Free State Foundation, I pointed out, I think this is a market failure, frankly. Consumers cannot make informed decisions about which services to use, which apps to download, unless they understand what's happening to their data. And so I think steps toward greater transparency are incredibly important in addressing this market failure. And so I think federal privacy legislation will go a long way toward addressing that aspect of the social media market about which a lot of us are concerned. That said, it would take 76 days of the average person's life to read every privacy policy and every caveat that comes with using those apps. And so I think an important
How
part
did
of
you
federal
calculate that number?
I did not spend 76 days of my life conducting that study. It's a study that was conducted, and I'd be happy to get that study to you.
Sounds about right.
But the point is that some accountability needs to be imposed on companies that are stewards of our data. And I think that too will be important in building trust in social media companies and tech companies generally. And that will be good for innovation and for consumers. Second, I think the Section 230 issues that you mentioned are incredibly important, right? The social media companies face challenges around content moderation, and we've been grappling a lot with that, especially around the last election. Now, during the Trump administration, the DOJ made, I think, some very interesting proposals related to content moderation, one of which was to grant immunity for moderation decisions done in accordance with plain and particular terms of service, which is a narrower scope than existing immunity rights under Section 230. Now, the goal is not to undercut the ability of social media companies to moderate content, because the DOJ recognized these companies have entrenched First Amendment rights to promote or remove content from their services. Instead, the desire is to remove the blanket immunity from liability for content moderation decisions, unless the platforms relied on and abided by their terms of service. Look, you and I have talked about this before, Randy. I think that this blanket immunity is in fact an intrusion into the market that government has undertaken that in fact likely has had a significant impact in the way that competition in the market has unfolded. And I would much rather have competition play out without government intervention. And many who've studied the legislation have concluded that, in fact, the way the courts have interpreted Section 230 has gone beyond what Congress originally intended. So look, I am not interested in having the FTC be the speech police here, but Brendan Carr at the FCC and others have said there may be a light touch way to address these issues. For example, if technology companies are going to propose detailed disclosures about content moderation policies, and violations of those disclosures could be enforced by the FTC. The FTC is not equipped to judge political speech issues, but that is not our role. But it could be interesting if we're asked to essentially determine whether companies are making representations about their terms of service and then not living up to them. But in the end, I think that the issue of those proposals is to create more transparency for consumers about what happens to their data and to their posts. And in the end, I always think that more transparency allows for more informed purchasing and user decisions on the part of consumers. And so I'm always in favor of more transparency.
Commissioner Phillips, why don't you have at it, add, subtract, whatever?
So I'd highlight a few points of sort of fundamental agreement. First, moderation decisions are governed by the First Amendment of the Constitution. Private companies, right, get to do this. Section 230 relates to tort liability, right? And it's important to keep that distinction in mind. These are different things. The second, I agree with Commissioner Wilson that the FTC's role has not been and should not be to regulate speech. We're not good at that. That's not a proper role for government. I don't know how you evaluate as a consumer protection matter, whether someone is biased or not. That question begs, right, a lot of political evaluation, and that's not what we do or what we should do. So I think that's all right. I think to me, the question with Section 230 is, my view is you want a flowering of speech. I think in the main, the operation of the law over many years has been to permit, right, to reduce liability and permit more speech. And I think, and I was saying this yesterday in a hearing in the House Judiciary Committee, I think I'm not a 230 expert, so I don't know the particulars of the operation of the law, but what Congress ought to go for is encouragement for more speech.
Okay, one thing I'll just add quickly, because at the Free State Foundation, from the inception, we've always taken a big part of our role to be defenders of First Amendment rights and free speech, and we've always had that as our mission right up on our website. But I've spent a lot of time trying to explain to people that the First Amendment right of Twitter and Facebook and so forth to put up and take down or modify whatever they want to on their website, I think is protected by the First Amendment. And there are a lot of things that I disagree with that they do, but I believe that's their First Amendment right. But that's very different from claiming that any alteration of Section 230 in terms of eliminating or revising in some way, even small ways, is a First Amendment violation necessarily. And I just say that because those platforms, some of the platforms and some of those, that take the view of the platforms continually conflate those two things and make the claim that it's a First Amendment violation if you reduce that liability. And, we have New York Times v. Sullivan, which applies to the print publishers, and that establishes a certain high bar of immunity, but that was a judicially created doctrine. I don't think anyone claimed that the newspapers had a First Amendment right to have Congress adopt a certain level of immunity. And anyway, I think it's worth pointing that out for those of us who do believe that it's important to defend First Amendment rights. I'm just going to, we have a question, and by the way, attendees, you can begin to put other questions in the chat function, but I have one from Ashley Baker, for whom I have great respect. So I'm just going to read her question to see whether there's anything to add. Do you think that the 230 debate and the debate over a federal privacy law are at least somewhat a dead letter now that many advocates have realized that antitrust is more powerful, and wrongly, she adds parenthetically, that it's easier? So, that's maybe one of you could take that. And in doing that, because this was going to be our next area of inquiry and sort of the last substantive area, she mentioned the federal privacy law. If I could ask you to build into your answer what you think the prospects are for a federal privacy law, and just briefly, we can do a whole nother webinar on privacy, but maybe you have a comment about that as well. Commissioner Phillips, you want to go first on this?
Sure. I think my answer to the question is no. I don't think they are dead letter. I think while there are certainly people who act as if antitrust can, should, will solve every problem they attribute to all sorts of large companies, right? Not just tech companies, but in particular tech companies. Like Commissioner Wilson said, there are a bunch of different issues people are talking about, right? However you feel about it, 230 speaks to moderation. Privacy law speaks to the confidence people have that their data is being kept, their understanding of what's happening to it. Antitrust speaks to competition problems. And so I think that because there are different issues people are talking about, I think all of these conversations are and will remain live. And I think that's how it should be. I don't think it should just be one conversation. Sorry. Happy to hear from Christine.
Christine?
You want me? Sure. So I hope that NOAA is correct. I think it is incredibly important for Congress to pass federal privacy legislation in particular. I think that, as an aside, I think that if there are limits on the kinds of data that can be collected and the uses to which they can be put, it may establish some guardrails for the larger tech companies and may allow some breathing room for smaller companies to enter and flourish. But with respect to federal privacy legislation, look, there are a number of different privacy regimes that are developing around the world, and the Federal Trade Commission has essentially this common law body of privacy enforcement, but we do not have federal privacy legislation, and therefore we do not have a seat at the table. I described earlier the ways in which the FTC and DOJ have driven consensus with respect to sound antitrust enforcement principles in the international community over the last, at least 20 years since the creation of the International Competition Network. We do not even have a seat at the table in international discussions regarding privacy and data security because we do not have federal privacy and data security laws beyond essentially certain sectoral laws like HIPAA and COPPA. And so we have this emerging patchwork that we see internationally, but also within the United States. Obviously, we have the California legislation on privacy. We have now in Virginia, privacy, and lots of other states are talking about enacting privacy legislation. And businesses need predictability and certainty regarding what kinds of data collection and use are appropriate. And it is incredibly difficult to drive compliance, and it's also very expensive to drive compliance when you're looking at a patchwork of systems. And ultimately, with increased expense comes increased cost for consumers. And then I think as a third point, we need federal privacy legislation, again, for consumers, for transparency, so they understand what's happening with respect to their data collection and use and monetization. And then finally, I think, and this is, it's a point that I always try to drive home, this is not just about commercial data collection and use. Because Fourth Amendment cases look at a reasonable expectation of privacy to determine whether a search runs afoul of Fourth Amendment rights, there's a connection that we cannot deny between commercial collection and use and government use of data. And my concern is that when all data is collected and we have no expectation of privacy in the commercial sector, it is much more easy for courts to find that we have no reasonable expectation of privacy with respect to our Fourth Amendment rights. And so I think our civil liberties are being infringed on a growing basis. And we've seen this especially play out in spades, given COVID, the pandemic, the use of data in completely unanticipated ways, including by government actors, to determine whether quarantines are being people are following quarantine orders and other health-related issues. And so I'm incredibly concerned that we are facing growing infringement of our civil liberties, and federal privacy legislation is going to be an important step to halting that infringement.
Okay, Commissioner Phillips, I'm going to call on you, but maybe we're getting closer to the end, and so I'm going to play a little bit like Chris Wallace and say, if not quite lightning rounds, I'm going to try to get to just a couple of other things. But so if you would add whatever you'd like on the privacy law, but specifically, I know that Commissioner Wilson recently proposed, if I have this right, that she might support a Magnuson-Moss rulemaking on privacy at the FTC. And of course, you can explain what that implies, that type of rulemaking, but for a couple of decades, they've been largely, that's been verboten, but Congress, of course, continues to not to act on privacy. So take that and speak to us about privacy and Magnuson-Moss possibilities at the FTC.
Sure. So just briefly, because I know you want to get to questions, and I think we all do, Magnuson-Moss refers to the statute that governs our ability to make consumer Commission rules. It's a longer process than we have under the Administrative Procedures Act for some statutes, for some areas. But the theory here is you can make a privacy rule using that mechanism. Commissioner Wilson and I differ a little. And my two big quibbles with that approach to privacy are first that, privacy legislation is hard because it involves difficult trade-offs. I think, there's a good case to do it, but the best people to make those trade-offs aren't a majority of FTC commissioners or even a consensus of FTC commissioners, but rather Congress. I think Congress is the right place to take those kind of big weighing steps. And my second issue, a big part of what people have been talking about as part of a privacy bill is having one uniform law for the nation, right? Something that we could take internationally, like Commissioner Wilson was talking about, something consumers could understand even when they crossed over from Texas, to Oklahoma, wherever they're going, that they would have the same rule, and something that businesses can rely on, not to have to abide by many state laws. It is very hard for me to see how preemption comes out of the MAGMOS process. And that's one of the reasons I think this really ought to be a congressional initiative.
And so one point I would make in response, I acknowledge that a MAGMOS proceeding is not ideal. It's not the second or even third best solution. But I think when we have business interest, consumer interest, a patchwork of laws and our civil liberties at stake, and Congress has failed to act for years and years and years, there is a small step that the FTC can take, albeit a suboptimal one, in terms of beginning to gather input from stakeholders. And hopefully Congress will pass federal privacy legislation, and the input that we have gathered will help us to provide technical assistance to Congress. But in the event Congress still hasn't acted in 5 years, perhaps we can be further down the road and establish some guardrails for businesses and provide transparency to consumers. Because again, this is a Fourth Amendment issue, it's a First Amendment issue, and I am gravely concerned about the developments that I'm seeing in the marketplace right now.
Well, those answers are really helpful. One of the things most helpful to me that I take away from that is that I'm going to start referring to the rulemaking as just MAGMOS rather than trying to get the whole darn thing out. Okay, now, Ted, in just a moment, if you have one further question on privacy, I know there are probably others, but we'll come back and do another webinar. You can ask that. In the meantime, if anyone, I see one question in the chat room, which I'm going to ask.
How about if we go to the chat room?
If anyone else has a question, you could put it up in the chat. And Ted, maybe you have a quick question.
Quick one. Yeah. Okay. Well, yes, the European Union is taking more of a regulation approach to privacy. The European countries and also the Union itself. What do you think about that kind of approach, more regulatory?
I would say we always need to be concerned about regulatory approaches that choose winners and losers. There are lessons that we can learn from GDPR. I think in particular, GDPR imposed some restraints that actually drove out existing competition and concentrated market power in the hands of larger incumbents. And so when we enact federal privacy legislation, I think we need to be very careful about ensuring that our approach fosters competition and innovation. And second, I would note, with respect to the EU, and going back to some of the issues we were talking about earlier, a regulatory approach that seeks to choose winners and losers inevitably is going to leave consumers worse off. We saw in railroads and airlines what happened when we had a heavy-handed ICC and CAB. And I thought it was fascinating that the House Judiciary Committee staff report said we should take railroad regulations and essentially impose them on big tech. Those are a good model. Nowhere in 450 pages of text and 2,500 footnotes did the staff report mention that, in fact, railroad legislation was repealed on a bipartisan basis because there was a bipartisan consensus that in the end, those regulations harmed consumers and stifled innovation and led to higher prices and lower output. And so when we're talking about a regulatory approach, we need to recognize that almost inevitably, we are acting without complete information and we are going to do more harm than good.
Okay, well, maybe this will be our final question. We have a question posed by Carl Hirschenroder. Carl, I apologize if I mispronounce your name. Carl is with Communications Daily. And his question is this. Acting Chair Slaughter said at yesterday's hearing that the FTC should consider withdrawing vertical guidelines issued by Chairman Joe Simons with DOJ. Do either of you have any thoughts about this suggestion?
Sure.
Commissioner Phillips, you were there at the time, I guess.
Well, we were both there, and we both voted to adopt the vertical guidelines. So I think I would start with no, they shouldn't be. They shouldn't be repealed. That's thing number one. Thing number two, it is an interesting proposal in light of the fact that one of the things we heard from a lot of folks at the hearing yesterday, and I was there too, was that antitrust needs more clear rules. So it's a little odd to start out with the goal of clear rules with getting rid of some of the rules. Look, I am always open to new approaches and new thoughts of how things can get better. I'm very interested in hearing from the acting chair and others what it is that they want on vertical mergers and the basis they have to support what they want, sort of evidentiary basis to support the rule. We haven't heard either of those things yet. And I think without that, there's no reason to bring down the vertical merger guidelines, which I think are good.
Commissioner Wilson?
I would echo what Noah has said. I think when you look at the vertical merger guidelines that were enacted, they were enacted on the basis of empirical analysis, retrospectives that the agency has conducted, and with regard to sound data and sound antitrust enforcement practices. The vertical merger guidelines do not say that all or almost all vertical mergers are lawful and beneficial. They say that under certain circumstances, there can be consumer harms that arise, and in those instances, the agency should act. But it also does acknowledge that there are benefits to vertical integration that are founded on decades of analysis and research and retrospectives. And so I think, again, it is important not to paint with too broad a brush, which I think sometimes our colleagues are inclined to do, especially with respect to vertical mergers. I think each case needs to be analyzed on its own merits with respect to the particular fact at hand. And I think the vertical merger guidelines provide a great roadmap for doing that.
Thank you. So in just a moment, I'm going to properly thank our speakers today. But before I do that, I just want to remind our audience that on Tuesday, we're going to have another fireside chat, this time with FCC Commissioner Brendan Carr. As those in attendance saw today, there's some areas where there's some useful analogies and learning from one agency to the other. So I bet we'll go back over a bit of that. And here's a trigger warning for those listening, that we're going to ask Commissioner Carr about Section 230 as well, because he's been fairly outspoken on that. So we look forward to that event. Now, I really want to thank Commissioner Wilson, Commissioner Phillips, both of you being with us today, and of course Ted for joining me in the questioning. I have to say I always learn a lot when I listen to either Commissioner Phillips or Commissioner Wilson. Every time I have a chance to listen to them separately, but when you have them both together at one time, I think my learning is doubled. So it was for me And I know for our audience, very informative, educational, and important. So thank you both. We look forward to having you again with us soon, hopefully the next time in person. But thanks so much to both of you. So now I'm going to, oh, by the way, I want to mention that I've been informed C-SPAN is going to broadcast this event. We've been fortunate that this will be our third event this year that C-SPAN has broadcast, and so you can check the C-SPAN website and see when the broadcast will occur. Thanks again, Christine and Noah, Ted. So I'm going to say goodbye now until we meet again. Thank you.
Thank you, Randy.
Thank you.
Ted.
Thank you.
Thanks so much to both of you. Take care, everybody.
Thanks.
Everybody take care.